Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're in session number 5 of our new series entitled The Slippery Slope of Substantial Medical Evidence. And I have a fascinating discussion for you today, one that I'm sure that's going to benefit you on the very next case that you have that involves a permanent impairment rating. Now, cases that involve a permanent impairment rating represent about 1/3 of all the cases that we see as qualified medical evaluators. So the information that I want to share with you in today's discussion is going to be very, very important for you for a large percentage of the numbers of cases that you actually see. And before we get into the topics of today's discussion, let's just briefly review the philosophy of this program. And then let's just briefly review where we've come from so far in this program. Now, this program is all about substantial medical evidence. And substantial medical evidence refers to how you formulate and how you format every single opinion and conclusion that you offer in your QME report. And providing opinions and conclusions that qualify as substantial medical evidence is a lot like a game. It's a lot like a game that involves players and that involves pieces. And if you can move your players and pieces around in a systematic fashion, you can win the game. And the way you win the game as a qualified medical evaluator is by providing opinions and conclusions that are always correct. They're always the correct and accurate opinion and conclusion every single time. Now, wouldn't it be great if you could live in a world where you were personally correct all the time? Wouldn't that be great to always be correct? Well, as a qualified medical evaluator, you can always be correct when you follow the system. The system is called the medical decision-making system of substantial medical evidence. And we talked about the players and the pieces that you're going to employ in fashioning your opinions and conclusions that were highlighted for us in these historic cases, the Zemke case, the Garza case, the West, Granado, and most recently the Escobedo cases. These cases contain the ingredients, the pieces of your opinion that are going to allow you to win. And if you can use these pieces exactly according to the recipe, exactly according to the system, you can rely on this as a system of medical decision making every single time in your report where an opinion or conclusion is required of you. And this is in many, many sections of your report, not just in the permanent impairment section, which we're going to talk about today, but also in the causation section of your report, also in the physical examination section of your report, also in the apportionment section of your report. In every single section of your report where you stick your neck out to offer an opinion or a conclusion, you must qualify that opinion and conclusion as a substantial opinion or conclusion. And if you can do it, you can relax and rely on that, and you can realize that you've always made the correct decision based upon the information that you have available to you at the time. Now, that's not to say that you might not change or modify your opinion or conclusion if new information becomes available. We always have that option. We can always change our opinion or conclusion based on new information. But at the time, based on the information that you had available, you used that information, you ran it through the system, and at the end of the system, out popped the opinion and conclusion that was the naturally correct opinion and conclusion based upon the information that was available at the time. So you can relax knowing that you're always correct based upon the information that you had. In each one of our sessions, including today's session, I'm showing you how to integrate substantial medical evidence into the appropriate sections in your report. And in today's discussion, we're going to talk about the permanent impairment section of your report. And I'm showing you how to fashion your language in your report such that every opinion that you offer is a solid rock. It's a substantial opinion upon which the parties can resolve disputed issues. in the case. And then finally, in order to help us improve, I'm showing you and sharing with you some case examples that illustrate the principles in each of the discussions that we're having. And I'm showing you case examples on both sides of the coin. Case law examples where the qualified medical evaluator succeeded in having his or her opinion and conclusion upheld because he or she succeeded in qualifying the opinion and conclusion as substantial medical evidence. So that's the one side of the coin. And then on the other side of the coin, I'm showing you some cases and sharing with you some cases where the qualified medical evaluator failed in having his or her opinions and conclusions upheld because he or she failed in being able to qualify those opinions and conclusions as substantial medical evidence. So this is the philosophy that we're striving toward in this program. And let's now briefly discuss some of what we've discussed in sessions 1 through 4 of this program. In session 1 of this program, we reviewed the historic cases that give us the definitions of substantial medical evidence. And this had to do with the Garza case, the Granado case, the West case, and the Escobedo case. And these cases, these historic cases, some of them going back over 50 years, much longer than you or even I have been around, these cases give us the pieces of the parts of our opinions and conclusions. And you should be familiar, almost to the point that you can quote these pieces and these parts. So let's see how many of the definitions of substantial medical evidence we can describe just from memory. So remember that these cases told us that in order for our opinions and conclusions to qualify as substantial, they must, number one, must be predicated on reasonable medical probability. Reasonable medical probability. So that's step number one, is when you offer your opinion or conclusion, you offer it based on reasonable medical probability, which means that your opinion or conclusion has a 51% or greater likelihood of being the correct opinion or conclusion. So as you look at your opinion or conclusion, you ask yourself, first step, is this opinion or conclusion reasonably, medically, probably correct? If your opinion or conclusion cannot even satisfy this criteria, it's because your opinion and conclusion is not correct. It's because you have some motive. You have some incentive. You have some outcome that you're trying to create for the case by providing an opinion and conclusion that has no support. It has no substance behind it. And it can't even satisfy the reasonably, medically, probably correct number one criteria. Then you need to simply discard that opinion and conclusion and start over until you can come up with an opinion or conclusion that is at least 51% likelihood of being the correct and accurate opinion. So must be predicated on reasonable medical probability. Number two, the opinion or conclusion that you offer must be based on relevant facts. Relevant facts. So when you support your opinion or conclusion, you should cite the facts that are relevant and that support your opinion and conclusion. Now, many doctors, in an honest effort to try and qualify their opinions and conclusions, make one little error on this step, and that is when providing support for their opinion, they cite facts in support of their opinion and conclusion, but by review of the facts, it's clear that the facts are not actually relevant facts. So it's important that you look at the facts that you're citing in support of your opinion and conclusion and asking yourself, how is this fact relevant to my opinion or conclusion? That's the key inquiry. That's the key question. How is this fact relevant? Relevant to what? How is it relevant to your opinion or conclusion? Sometimes doctors will cite facts that are true facts from the case. There was a 2mm disc bulge at L5. The examinee reported the incident immediately, and they list all these facts that are true facts, but the facts do not necessarily support the opinion or conclusion because they're not relevant to the opinion or conclusion. So relevant facts must be facts that are relevant to the opinion or conclusion. So that's step number 2, is to list out your facts and make sure that they're relevant and supportive of the opinion or conclusion. The opinion must explain how and why. It must provide how and why reasoning as to how and why this opinion is actually correct. An opinion is not substantial medical evidence if it's based on facts no longer germane. Those are basically, in other words, those are irrelevant facts. Facts no longer germane could be rephrased as irrelevant facts, okay? If the opinion or conclusion is based on incorrect legal theories, and if the opinion or conclusion is any way based on speculation, conjecture, surmise, or guess. So these are the filters that we run our opinions through to qualify them as substantial medical evidence. In session number 2, I shared with you how you can be correct on AOE-COE 100% of the time, and this is at no time has this ever been more important than now when we're flooded with case after case after case that involves a denied case for which our opinion on AOE-COE is being required. So when providing your opinion or conclusion on AOE-COE, it's critical that that opinion or conclusion be correct. In other words, the stakes involved are so high for all of the parties. The stakes for the employee who may potentially have been injured on the job. The stakes for the employer who may potentially have to pay for who knows what dollar volume of benefits the employer may be on the hook for in the case of a bona fide industrial injury. And the stakes are high for the employer who is running a job site now without possibly one additional worker. In other words, the stakes are so high that the opinion and conclusion on AOE-COE must be absolutely correct 100% of the time. And I showed you a medical decision-making system to qualify your opinions and conclusions on AOE-COE as substantial and thereby make them correct 100% of the time. And that session alone was extremely valuable session. In session number 3, we took some time to illustrate some of the principles of substantial medical evidence. And I shared with you 2 cases where the medical evaluator's opinions were found to be not substantial. And we had one case where the medical evaluator had some incorrect legal theories with regards to AOE-COE, and it was found that the qualified medical evaluator did not really understand the concept of a cumulative trauma injury. And so his opinions on AOE-COE were found to be not substantial, and he was replaced. And in the second case, it involved a permanent impairment discussion, wherein the qualified medical evaluator failed to provide his formulation of the permanent impairment percentage. So the qualified medical evaluator provided a percentage of permanent impairment, but did not explain how and why he arrived at the percentage. So how and why reasoning and the use of correct legal theories, of course, are critical criteria to satisfy in qualifying your opinions as substantial. In session number 4, we talked about substantial medical evidence and the apportionment determination, and we talked about the 2 main labor codes that govern apportionment here in the state of California, which is Labor Code 4663 and Labor Code 4664. And to illustrate some principles related to that, we talked about the Romano versus Providence Health and Services case, where the qualified medical evaluator's opinion on apportionment were found to be not substantial because the qualified medical evaluator did not properly apportion the disability. He did not apportion the disability. So in supporting his apportionment approximate percentages, he employed incorrect legal theories And instead of apportioning the disability, which is required by Labor Code 4663, you see, it's the disability that we apportion. Nothing else gets apportioned. Medical care doesn't get apportioned. Benefits don't get apportioned. Symptoms don't get apportioned between various causes of symptoms. It's only the disability that gets apportioned. He apportioned to the examinee's overall condition, whereas he should have been apportioning the examinee's impairment. And so his opinions were found to be not substantial, and the qualified medical evaluator in that case was replaced. Okay? Now, in today's session, I want to talk to you about substantial medical evidence and your permanent impairment opinion. And it's important that you qualify your permanent impairment opinions as substantial in every single case. And this applies whether you're providing a permanent impairment opinion under the strict application of the AMA guides. It's important that you qualify that permanent impairment rating as substantial. And then in the alternative, if you employ an alternative impairment rating under Almaraz and Guzman, your permanent impairment rating under Almaraz and Guzman must go through an additional step, or an additional 4 steps actually, to qualify that alternative impairment rating as an alternative impairment rating that will be upheld by the parties. And it's important to remember that when we employ alternative impairment ratings under Almaraz and Guzman, that alternative impairment rating has the net effect of doubling, tripling, quadrupling, hectupling, and even decoupling and more the permanent impairment rating under the strict application of the AMA guides. So if you're going to provide an alternative impairment rating that has the potential to hugely increase the examinee's permanent impairment rating, you know that alternative impairment rating is going to get some scrutiny, at least by the defense attorney and at least by the claims administrator, if not even the applicant attorney. So it's critical, it's critical that that opinion for an alternative impairment rating qualify as a substantial medical evidence opinion. And I'm going to share with you exactly how to do that in those cases where you decide that an alternative impairment rating is the most accurate description of the examinee's impairment. Okay? So with that as our introduction, let's get into today's discussion regarding permanent impairment ratings and substantial medical evidence. And let's see what the state of California has to say about describing and formulating our permanent impairment ratings. So in the state of California, when an injured worker is declared to be permanent and stationary, establishing that injured worker's permanent disability rating, whether that permanent disability rating be 0% permanent disability, or whether that permanent disability rating be 100% permanent and total disability, establishing the percentage of permanent disability is a big deal. And it's a process that's taken very seriously by the system. And we as qualified medical evaluators, we participate in determining the percentage of permanent disability. And there's 3 basic considerations that go into establishing a permanent disability rating for an injured employee. And those 3 factors are described in Labor Code 4660A. So let's review 4660A here. 4660A tells us that in determining the percentages of permanent disability, account shall be taken of 3 things. 3 things. Number 1, the nature of the physical injury or disfigurement. Now, this is where we as qualified medical evaluators come into the system. Our job is to tell the parties what is the nature of the physical injury or disfigurement, and that's the conclusion of our qualified medical evaluation report. The conclusion, the purpose of a qualified medical evaluation report is to tell the parties what is the nature of the injury or the disfigurement. And as qualified medical evaluators, we do this by providing an impairment rating. Okay, and we'll talk a little bit more about that in a second. So that's one thing that goes into the formulation of the injured employee's permanent disability percentage. The second thing is the occupation of the injured employee. And down at the Disability Evaluation Unit, they have a listing of occupations that they match with the occupation of our examinee. So the examinee is matched to a code that most closely describes the examinee's occupation, and there's hundreds and hundreds of occupation codes. So that's number 2 that goes into the formulation of the permanent disability percentages. And then the third thing is the employee's age at the time of the injury. And all of these 3 factors that contribute to the permanent disability percentage give consideration to the employee's diminished future earning capacity adjustment factor. So as an example, you can see that the nature of the physical injury or disfigurement could more or less affect an employee's future earning capacity. Depending upon the nature of the injury, could certainly affect the injured employee's capacity for even going back to work. Maybe the employee cannot go back to work and he's completely lost his future earning capacity as a result of the injury. Okay. Number 2, the occupation of the injured employee based upon the injury or disfigurement may more or less be impacted and may more or less impact the future earning capacity based upon that injury. So let me give you an example. Let's say the nature of the physical injury or disfigurement has to do with an ankle injury that leaves the examinee with some ankle ankylosis that affects weight bearing, that affects ambulation. Okay, you get the point. Well, how important is ambulation and weight bearing in an examinee whose occupation is a pianist, which is a sit-down occupation? Is the injured employee's future earning capacity going to be greatly impacted by an ankle injury when the occupation is that of a pianist? This is an occupation that is not greatly impacted by an ankle injury, and so this is a permanent disability rating that's going to rate lower, whereas if the occupation is someone who is on their feet all day, such as a registered nurse, such as a postal carrier. Okay, you get the point. And then finally, his or her age at the time of injury. An injury in a younger person who has many, many years of earning capacity left is going to be greater than an employee who is in their 60s or even beyond retirement age that has only a few years of future earning capacity left. All 3 of these things get juggled and assembled into formulating the permanent disability rating. Now, our job as qualified medical evaluators is to handle number 1, the nature of the physical injury or disfigurement. So let's see what Labor Code 4660 has to say about how we are to go about doing the important work that we do as qualified medical evaluators. So Labor Code section 4660B1 tells us that for the purposes of this section, in other words, for the purposes of establishing the permanent disability percentage, where it says that the factor of the nature of the physical injury or disfigurement, which is the domain of us as qualified medical evaluators, in describing the nature of the physical injury or disfigurement, the description shall incorporate the descriptions and measurements of physical impairments and the corresponding percentages of impairments published in the AMA guides. Now, historically, this is a very important section of the law. If you were around back in the days of the Almaraz and Guzman decisions, back in the early inception of the Almaraz and Guzman cases, one of the first conclusions of the Almaraz and Guzman line of cases is that we as a qualified medical evaluator could use outside references, outside sources, outside publications, outside studies, outside research articles in coming up with, at the time, what was referred to as a fair and proportionate permanent impairment rating. But it was found that going outside of the AMA guides was inconsistent with the law, which is Labor Code 4660B, which tells us that whatever we provide as a permanent impairment rating, whether we use a permanent impairment rating under the strict application of the AMA guides, or if we choose to use an alternative impairment rating under Almaraz and Guzman, whatever that rating is, it must incorporate the description and measurements and the corresponding percentages of permanent impairments that are described in the guides. So as we're going to see in providing for alternative impairment ratings, we can go throughout the four corners of the AMA guides in coming up with alternative impairment ratings, but we cannot go outside of the four corners of the AMA guides, because to go outside of the four corners of the AMA guides violates this section, which tells us that our permanent impairment description must incorporate the material from the AMA guides. And Labor Code 4660 continues, and it tells us that the scheduled rating, the schedule of ratings, in other words, the permanent impairment percentage coming out of the AMA guides, the scheduled rating shall be prima facie evidence of the percentage of permanent disability to be attributed to each injury covered by the schedule. Now, prima facie means that based upon the first impression, this percentage of permanent disability is accepted as correct until proven otherwise. This is critical for us to realize as qualified medical evaluators, that the scheduled rating, which comes out of the AMA guides, out of the strict application of the AMA guides, is accepted as correct until proven otherwise. It's in the law. It's in the law. The law tells us that the scheduled rating out of the AMA guides is the correct rating in every single case, but there is a process to prove that another impairment rating outside of the scheduled rating, in other words, an alternative impairment rating, may be more correct, may be more accurate. And the reason this is described into law under Labor Code 4660 is to carry out the purpose of invoking the use of the AMA guides in the first place, which occurred in 2004 with the passage of Senate Bill 899, is to provide some consistency, some uniformity, and some objectivity in the provision of permanent impairment ratings, and thus in the establishment of the injured employee's final permanent disability rating. The purpose of it is to create some consistency and some objectivity in the process, which prior to the implementation of the AMA guides, there was a lack of consistency and a lack of objectivity in providing for permanent disability ratings. So that was all well and good back in 2004 and 2005 as the AMA guides started to be increasingly adopted for use in establishing permanent disability ratings, and we were starting to see some consistency and some uniformity and some objectivity. And what became clear is that the permanent disability ratings, as a result of the use of the new AMA guides, was resulting in a new lowering compared to years prior to the adoption of the AMA guides, a new lower level of permanent disability ratings. And then some rumblings came around that changed all of that. And that had to do with the Almaraz and Guzman cases, wherein qualified medical evaluators provided for impairment ratings by reference to prior permanent disability rating schedules outside of the AMA guides. Well, after much deliberation, which took years, the key conclusions from the Almaraz and Guzman line of decisions radically changed how the permanent disability ratings were formulated as described in Senate Bill 899. And some of the key conclusions of the Almaraz and Guzman's decisions were, number one, that a permanent disability rating established by the schedule, in other words, established by taking into account the three things: the nature of the physical injury or disfigurement, the occupation of the employee at the time of the injury, and the age of the employee at the time of the injury. The schedule, the disability rating established by those three key components, is rebuttable. In other words, on first glance, it's prima facie evidence of the correctness of the permanent disability rating. It's prima facie evidence, but it's still rebuttable. It's still rebuttable by substantial medical evidence. And the burden of rebutting a scheduled permanent disability rating rests with the party who's disputing the permanent disability rating. Now, you're going to see in the cover letters that you get, especially those from the applicant attorney, that the applicant attorney is going to ask you to consider alternative impairment ratings because, as I said, traditionally, the scheduled rating used under the use of the AMA guides are newly lowered and newly conservative permanent impairment ratings prior to the ratings before the adoption of the AMA guides. So especially the applicant attorneys are going to ask you to consider an alternative impairment rating as a more accurate rating of their client's true condition. So you're going to see that the burden mostly falls upon those who are rebutting the new conservative and new lower permanent disability ratings that are afforded by the AMA guides. One method, this is from the Almaraz and Guzman cases, key conclusions, is that one method of rebutting a scheduled rating is to successfully challenge one of the component elements of the rating, such as the whole person impairment under the AMA guides. And it's the whole person impairment under the AMA guides which is the most challengeable of the component elements of the rating. Less challengeable is the employee's occupation, okay? The employee's occupation is going to fit neatly into a set of codes down at the disability evaluation unit, and there's very little argument that can be made that the employee fits into one occupation category compared to another occupation category. Secondly, it's going to be difficult to make much impact on the permanent disability rating by challenging the employee's age at the time of the injury. Okay, so of the three elements that go into the formulation of the permanent disability rating, the disability percentage, the most challengeable is the whole person impairment rating under the AMA guides. And this is where we as qualified medical evaluators are going to be pursued by the parties to consider an alternative impairment rating under Almaraz and Guzman. And I have an interesting case to share with you on that in just a moment. And finally, key take-home message from the Almaraz and Guzman cases is that a physician may utilize any chapter, any table, any chart, any method in the AMA guides that most accurately, keyword is accurately, most accurately reflects the injured employee's impairment. And this satisfies the prior description in Labor Code 4660B, I think it was, that the nature of the physical injury or disfigurement must come out of the AMA guides. So as long as we remain within the four corners of the AMA guides, we can use any chart in the AMA guides, any table, any chapter, any method, any figure, any description in the AMA guides that most accurately reflects the injured employee's impairment, we can use with one caveat. And that has to do with the fact that using alternative impairment ratings to more accurately describe the injured employee's impairment has the net effect of increasing the permanent impairment rating. In other words, no one ever uses alternative impairment ratings to provide for a lower permanent impairment rating that's offered by the schedule, that's offered under the strict application of the AMA guides. The purpose of using alternative impairment ratings under Almaraz and Guzman is to escape the conservative impairment ratings of the schedule and provide for higher permanent impairment ratings that presumably are more accurate than the prima facie correct rating under the strict application of the AMA guides. And so if you're going to do it, your description of it and your explanation for it has to be good, because this, more than anything else, is going to draw the scrutiny of the parties, and you will be interrogated as to your alternative impairment rating. But that's okay, because there's a way to do it, and if you can follow the system in formulating your opinion for an alternative impairment rating, that alternative impairment rating will be the most accurate rating every single time, and you can relax knowing that you have provided for the most accurate permanent impairment rating. So what are our obligations as qualified medical evaluators? Our obligation as qualified medical evaluators is to provide the most accurate permanent impairment rating so that the injured employee can receive the permanent disability rating that's exactly correct, that's exactly accurate, that's exactly appropriate for the diminished future earning capacity that they suffer as a result of their industrial injury. Any impairment percentage that's not the most accurate percentage does a disservice to one or more of the parties involved with the case, including possibly to the injured employee, and that's not something that we want to entertain. So as qualified medical evaluators, it's critical that our opinion or conclusion on a permanent impairment rating be the most accurate for the injured employee's actual condition, and that the opinion and conclusion be supported with substantial medical evidence so that the injured employee receives the proper permanent disability rating. So another key conclusion from the Almaraz and Guzman cases is that alternative impairment ratings, a consideration of an alternative impairment rating, is required in every single case that involves a permanent impairment rating. Now, if your examinee is not yet permanent and stationary, of course, you're not discussing permanent impairment, so a consideration to an alternative impairment rating is not necessary. But when the examinee is at maximum medical improvement and the examinee is permanent and stationary, and you do provide for a permanent impairment rating for the examinee by using the specific chapter, chart, table in the AMA guides, it's required that you also give consideration to an alternative impairment rating under Almaraz and Guzman in every single case, because to do so constitutes what's considered to be a complete medical evaluation. We'll talk a little bit more about that in just a minute. Now, it doesn't mean that you have to provide an alternative impairment rating out of another chapter, out of another chart, out of another table. You don't have to provide an alternative impairment rating in every single case. It says that you must consider an alternative impairment rating in every single case, and you must consider some of the other charts, some of the other chapters, some of the other tables, and consider whether or not there is another description in the AMA guides that is more accurate than the description under the scheduled rating under the strict application of the AMA guides. To fail to do so, to fail to give consideration, results in the opposite of a complete medical evaluation, which is an incomplete medical evaluation, and the opinion therefore on permanent impairment will not qualify as a substantial medical evidence opinion. And a key conclusion from the Guzman case tells us that to accommodate those complex or extraordinary cases that don't neatly fit into the permanent impairment ratings under the strict application of the AMA guides, tells us that the AMA guides call for the physician's exercise of clinical judgment to evaluate the impairment most accurately, even if that is possible only by resorting to comparable conditions described in the AMA guides. Comparable conditions such as what? Well, how about conditions that create comparable limitations to activities of daily living? This is one example as to how you can use the AMA guides in providing for an alternative impairment rating. You look through the four corners of the AMA guides and look for conditions like your examinee's condition, conditions that cause same or similar limitations to activities of daily living that your examinee's condition causes. And this is how you can create an analogy within the four corners of the AMA guides and provide for an alternative impairment rating under the AMA guides. And the Guzman, Almaraz and Guzman decisions, which are en banc binding decisions across all the courts throughout the state of California, tell us that this is required in every single case. So whether you like it or not, it's required. So let's talk about a case where a qualified medical evaluator didn't like it. Didn't feel that there was any merit to Almaraz and Guzman alternative impairment ratings, and chose not to even give consideration to an alternative impairment rating within the four corners of the AMA guides. So in 2014, there was a case, the Sineth versus Wells Fargo Bank case, wherein the qualified medical evaluator provided for a permanent impairment rating under the strict application of the AMA guides. In other words, he provided a permanent impairment rating by use of the scheduled rating under the AMA guides, under the strict application of the AMA guides using the chart, chapter, table specific to Sineth's condition. Well, one party chose to rebut the scheduled rating. They assumed their burden and they deposed the doctor, and they asked the doctor to please give consideration to an alternative impairment rating within the four corners of the AMA guides to possibly come up with a more accurate, meaning a higher permanent impairment rating that would better reflect the injured employee's diminished future earning capacity. And the qualified medical evaluator refused to do so. And the qualified medical evaluator stated that said, in regard to the question of Almaraz Guzman, I am of a mind with Dr. Damore. Dr. Damore was the primary treating physician who also provided a permanent impairment rating under the strict application of the AMA guides, but who refused to provide an alternative impairment rating, or who refused to consider an alternative impairment rating under Almaraz and Guzman. He said that both he, the qualified medical evaluator, and the primary treating physician agree that Almaraz Guzman is basically a legalistic ploy that attempts to insinuate subjective complaints as a factor in the impairment rating. He says, like Dr. Damore, I use the AMA guides, and I do not and never will use Almaraz and Guzman. And here, by stating that he does not and he never will, never is a long time, never is an emphatic statement. This is where the qualified medical evaluator lost control of the case, and his opinion on permanent impairment under the strict application failed to rise to the level of a complete medical evaluation, and therefore the permanent impairment rating did not qualify as substantial medical evidence. And because he stated that he never would use Almaraz and Guzman, he was replaced from the case. And let's see how the judge defined the qualified medical evaluator's philosophy. So what happened was the workers' compensation judge decided that because the qualified medical evaluator refused to consider an alternative impairment rating under Almaraz and Guzman, the workers' compensation judge opined that it was appropriate to remove the qualified medical evaluator and to obtain a new evaluator. Well, of course, the defendant, in this case, the defendant objected to that, and the defendant filed a petition for removal, requesting that the appeals board rescind the finding and order wherein the presiding workers' compensation judge found that there is good cause to remove the qualified medical evaluator in this case, and the workers' compensation judge ordered the medical unit to issue a new QME panel in orthopedic surgery. So the applicant contended that the permanent impairment rating provided for under the strict application of the AMA guides was not accurate, meaning that it was too low. And the defendant, of course, was of a different opinion. The defendant was happy with the low permanent impairment rating under the strict application of the AMA guides, and they therefore objected to the removal of the qualified medical evaluator. Well, the defendant contended that there's no legal basis for replacing the qualified medical evaluator because he has not violated the various requirements of 31.5 and CCR 41, and here's the key phrase, and because a QME is permitted but is not required to provide an alternative rating of permanent disability pursuant to Almaraz and Guzman, and the proper procedure for fixing the report of the qualified medical evaluator is further discovery, not replacement of the QME. So here, the defendant misunderstood the requirements and the conclusion of Almaraz and Guzman in that the QME is permitted, meaning the QME can provide an alternative impairment rating, but is not required to provide an alternative impairment rating in every single case. And this has some shred of truth to it, but it's not this nuance that caused the workers' compensation judge to feel it proper and appropriate to remove the qualified medical evaluator. Rather, it had to do with the qualified medical evaluator's overall stubborn and recalcitrant philosophy relating to all cases and all consideration of alternative impairment ratings. So the Workers' Compensation Appeals Board begins their argument by providing some background information, and they tell us that in Guzman, the Court of Appeal held that to accommodate those complex or extraordinary cases, the AMA guides calls for the physician's exercise of clinical judgment to evaluate the impairment most accurately, even if that is possible only by resorting to comparable conditions described in the AMA guides. Despite this holding, the qualified medical evaluator states categorically that he will never use this procedure, even though it is sanctioned by the court. And here is the conclusion that disqualifies Dr. Batchelor's permanent impairment opinion as not substantial. They tell us that a medical report predicated upon an incorrect legal theory cannot rise to a higher level than its own inadequate premises, such that he never will use Almaraz and Guzman alternative impairment ratings, because in his philosophy, alternative impairment ratings are a legalistic ploy, and he so stated in writing. Such reports do not constitute evidence to support a denial of full compensation, which is the purpose of providing accurate impairment ratings, is so that the injured employee can receive full compensation for an industrially caused disability. Thus, while Guzman does not require an evaluator to apply alternative procedures, the qualified medical evaluator states that he will not apply the procedures even if appropriate. He stated that he never will consider the accuracy of an alternative impairment rating. For this reason, the qualified medical evaluator's evaluation of applicant's permanent disability cannot constitute substantial evidence, because the qualified medical evaluator cannot provide a complete medical evaluation as required by 31.5A, 15A. Therefore, the medical director is required to provide a replacement panel. So, failure to consider an alternative impairment rating in every single case that involves a permanent impairment rating disqualifies the evaluation as an incomplete medical evaluation and serves as the basis for your replacement as a qualified medical evaluator. So the conclusion was that the defendant has not demonstrated that it will sustain substantial prejudice and or irreparable harm if a new QME panel issues. It has not demonstrated that it will suffer irreparable harm. In fact, there may be no harm. There may be no harm because it's possible that a new QME who understands his or her obligations under Guzman will still decide that the alternative procedure is not required in this case. So in that case, the permanent impairment rating would remain the same, or it could possibly become a higher permanent impairment rating if the new qualified medical evaluator does employ an alternative impairment rating under Almaraz and Guzman. But at this point, the new qualified medical evaluator may or may not opt for an alternative impairment rating, but a new qualified medical evaluator was required in this case because the prior qualified medical evaluator told us that he never ever would, under any circumstance, even give consideration to whether or not an alternative impairment rating would be the most accurate rating for the particular circumstances of the injured employee's condition. So doctors, isn't that fascinating? In those cases that involve a permanent impairment rating, the permanent impairment rating goes into the formulation of the injured employee's final permanent disability rating. And it's absolutely critical that that permanent impairment rating be accurate so that the injured employee can receive the compensation that they are entitled to for their diminished future earning capacity. It's critical that that permanent impairment rating be accurate. So in providing for accurate permanent impairment ratings, the law tells us, Labor Code 4660, that the nature of the injury or physical disfigurement shall incorporate the AMA guides, the descriptions and the measurements and the corresponding percentages of impairment of the AMA guides. So that's great. That's great. Now, under the strict application of the AMA guides, those permanent impairment ratings are going to be conservatively low because the AMA guides historically provide for lower and more conservative permanent disability ratings than the prior schedule prior to the adoption of the AMA guides. So one or the other of the parties are going to attempt to rebut the scheduled rating under the strict application of the AMA guides. And that's where you, as the qualified medical evaluator, have an obligation by law. As we saw, one qualified medical evaluator refused the obligation, but we have an obligation to at least consider the accuracy of other possible impairment ratings that may exist within the four corners of the AMA guides. And whether you come up with an alternative impairment rating or whether you decide that the strict application, the rating provided for under the strict application, is the most accurate description of the employee's impairment, whichever side of the coin you fall on, strict application or an alternative impairment rating, you must explain your rating such that the rating qualifies as substantial medical evidence. Only permanent impairment ratings that constitute substantial evidence can be used in the formulation of the permanent disability rating down at the disability evaluation unit. And in our next session, I'm going to show you exactly how to format your report and how to fashion your argument, whether that be under the strict application of the AMA guides or whether it be under an alternative impairment rating. I'm going to show you how to fashion your argument such that your opinion on the permanent impairment rating is irrefutable because it constitutes substantial medical evidence. So I look forward to being with you on our very next session where we go into those important topics. So I want to thank you for taking the time to join me on today's discussion. I hope you'll implement these ideas that we talked about today into your very next case that involves a permanent impairment rating. For now, this is Dr. Perry Carpenter. I'm looking forward to being with you on our very next session, and I'm wishing you best of success in your career as a qualified medical evaluator.